Design professionals are oftentimes given contract clauses that require them to perform their work in compliance with all laws and ordinances. This is not a problem. In fact, it's very typical to see that in the contract. But where it becomes a problem is when the architect is asked to comply with all laws and without any qualifiers. This is where we actually have to look at the contract much closer, especially with this type of clause. The clause should actually say in compliance with all applicable laws, ordinances, and codes. Because sometimes what happens is all codes actually do not apply to a project. I actually had an instance once where an owner who we had a contract with had actually thought that by saying all codes for a residential project, that would include commercial codes that were also included in the codes. So he was expecting, for example, fire ratings that were at a commercial level rather than a residential level. And this was a residential project. So in certain circumstances, having the word applicable was actually very important for us in negotiating and resolving a claim that was asserted by another owner. In addition to applicable, we also have a situation where you would want to add the word non-conflicting with regard to compliance with the laws clause. In that case, what happens there is sometimes you'll have a federal, a state, or a local rule or an ordinance that's actually in conflict with each other. What we've been recommending is if you include the word non-conflicting, then you have the opportunity to argue to an owner or a contractor. You identified a conflicting rule, but you took a more stringent approach to it, and therefore you complied with all laws, and even when there's conflict, you took the more stringent approach to applying those laws. So in addition to non-conflicting and applicable, we also like to include in the compliance with laws section a statement that this is going to be done consistent with the standard of care. This is important because oftentimes a design professional, when they're asked whether or not they complied with the law, is going to be asked whether or not they were aware of certain laws. Now, when we make the argument that they performed their duties within the standard of care and that they are endeavoring to actually comply with the laws and ordinances, this additional clause actually helps us make the argument. Sometimes what happens is an expert witness will come and say that the architect failed to comply with the laws. Well, there's an argument that it was not reasonable for that architect or engineer to be aware of certain rules and regulations that would apply. And so we can argue that they met the standard of care because it was reasonable for them to not know about a certain law or ordinance in a local jurisdiction or a federal rule or something that was not reasonably known to the architect or engineer. If you have a compliance with laws clause in your contract, if you can have that clause say that it's for all applicable laws and non-conflicting laws, and that it's consistent with the standard of care, I think you'll have a good compliance with laws clause in your contract.